Ari is our Microsoft Visiting Professor for the year. He is a professor of law and the founding director of the Innovation for Center of Law and Technology at New York's Law School. He's also an affiliate fellow of the Information Society Project at Yale Law School, and he holds a PhD in sociology from Columbia University and a JD from Harvard. I'll let Ari talk more about his research and.
Great. Thank you so much. I want to make sure I'm in the picture here. Thank you so much for coming. It looks like we're about running out of chairs, but there is room if there is room in front. So my name is Ari. I am very excited to be here this year, and I find this, I think this research is really interesting. I've been working on this long-term research project for about 3 years. And what's particularly helpful to me about giving a talk in an environment like this is that as a law professor and a sociologist, I tend to give talks like I'm doing this afternoon in front of lawyers and sociologists and other related groups. But here I have the benefit, it's wonderful to receive the benefit of insight from people from a variety of perspectives. Also, I'll note before I start, as someone who teaches law, I'm very used to people interrupting me. While raising your hands, of course, but very used to people interrupting me, so please do not feel like you have to wait until I'm done speaking before answering questions. I think that that's far more of an engaging way to spend the next hour than to just listen to someone speaking at the front of the room. So this project is called Privacy, Power, and Discourse. It's actually part of a larger research project that I've been doing over the last 3 or 4 years that is eventually going to turn into my second book. That book is not going to be called Law, it's just the icon that I found. But this is a project about where real power lies in the implementation of privacy law on the ground. So I started this research by identifying or noticing that there's great talk in law, in Congress, in courts, even among chief privacy officers and privacy professionals inside corporations about how important privacy is and about how it's now good for business and how even in companies advertising, you see Apple advertising their products as privacy protective products. And yet, when you actually look at the devices that we use every day, the websites that we use, there are several scholars here that are studying the manipulative ways in which websites and apps coerce us into sharing. There is this strong disconnect between discussions about how important privacy is and our actual experiences on the ground. So over the course of the last few years, I have done this research to explore different aspects of where real power lies in the implementation of privacy law. Some of these have come out or are coming out in other law review law review journals, and the overall insight, which for those people who have taken a Sociology 101 class or study sociology, the overall insight should not be very surprising. The insight is that people matter. It matters who are the people that are implementing the law. It matters who are the people that are translating legal requirements into design, and it matters who the people that are doing the design. So this is an important insight of sociology of law, the sociology of organizations. You can pass whatever law that you want, but if there are no guardrails around the implementation of the law, then that law is going to be undermined. This particular, so this argument is that real power over the implementation of privacy law rests really inside technology companies in general, and in particular with those people that are tasked with the design of technologies that integrate integrate or require disclosure. So this study has focused mostly, although not exclusively, on engineers, computer scientists, programmers, coders, the people who are doing the designing of products we use every day. This particular project that I'm going to talk about now is about the discourse of privacy. It's about how we think and how we talk about and the issues that we assume are related when we talk about privacy. As again, a sociologist may know, the concept of discourse is based on the work of this guy, Michel Foucault, who argued that discourse is more than just thinking about language. It's more than just words. They are ideas or bodies of knowledge or ideologies. The way we think about a subject, the way we think about our work, the way we think about how we go about our business when we talk about a particular concept. Foucault's work talked about homosexuality, talked about criminality, talked about the built-in assumptions of 20th century or 19th century dogmas around these concepts that have framed them in certain ways. And those framings end up subjugating or end up keeping down populations that are deemed as either gay or criminals or mad, right? So discourse, if you can control the discourse about something, you have extraordinary power over deciding how that concept plays out in real life. So I am concerned, as a result, I'm concerned about the discourse of privacy. So how do we go about thinking, how do people go about thinking about, talking about, and doing the work associated with privacy? And because I'm concerned about who is involved in translating privacy law requirements into real life, I'm interested in the discourses of different clusters of people. How scholars talk about and write about privacy that enters into the zeitgeist of how we all think, or the legal consciousness, to use Susan Silvy's term. How non-experts, how maybe not people in this room, because everyone here is probably an expert in technology, but non-experts, people outside this room who are using their devices and buying new iPhones for exorbitant prices. Privacy professionals who are the people who are the frontline people who are working inside companies to implement privacy protection, and I include in there general counsel offices, CPO offices inside companies, as well as civil society and so forth. And then, of course, this broad term, technologist. I know a lot of people, I think this word is a little bit controversial, but I use it as just kind of an umbrella term for the people that are doing the technology work. The engineers, the computer scientists, the designers, the coders who are translating these laws into practice. So let's talk a little bit about methods. How did I go about determining how these different groups think and talk about privacy? And again, as I mentioned, this is part of a longer-term research project that involves extensive interviews, being embedded inside the design meetings and design processes of several technology corporations, going to conferences where some of these people, whether it's technologists or privacy professionals, attend, and interviewing them, conducting semi-structured interviews both in person and on the phone. So it's a long-term project for which I got my own funding as opposed to relying on the funding of technology corporations. So for this project, yes?
Sorry, when you say privacy professionals,
yeah.
Is that exclusively lawyers or?
No,
okay.
Not exclusively lawyers. The population, it turns out, is about 60% JDs, based on a survey of the International Association of Privacy Professionals. But you can become a privacy professional, for those perhaps looking for a job, even without a JD. And in fact, the profession is actually looking for technology experts, social scientists, humanities experts to become privacy professionals. And I did make sure, that's a good point, Arvind, I did make sure that the people that I interviewed represented a variety of different backgrounds, because I was also interviewing general counsel at these companies, so why interview just all lawyers? So with respect to methods for this project, the work of scholars, you can read we can all read their texts and their articles. For the work of non-experts, there's actually some work out there done, I'll just go to actually the next screen. So with respect to scholars, non-experts, privacy professionals, and technologists, scholars, this is basically desk research. I'm employing the methods of critical discourse analysis that discourse theorists have developed, along with sociologists and STS scholars. This discourse is broad. You can imagine this is what academics do. We sit in our offices and we come up with ways to think about our concepts and privacy. The broadest concepts, the broadest breadth of privacy discourse, whether it's autonomy, thinking about privacy in terms of intimacy, choice, relationships, trust, context. This obviously comes from scholars. The discourse of non-experts, the best way to do this is to try to understand the mental frames, how people frame the way they think about technology. Some work in this area has been by Lori Craner, Sarah Kiesler, and Christina Nipper-Eng, who have done research directly on mental frames, but also done research on how people navigate their privacy in real life. Non-experts tend to think about privacy in terms of their lived experiences, things like diaries, barriers, walls, bathrooms, or things that are of their nature intimate, like sex or masturbation, or even some of them think about them in terms of choice. But the most powerful, and this is broad, but the most powerful factor here is the lived experiences of ordinary non-experts. These both are broad, and that they should be broad. But as we go forward and we continue on to this in this pyramid, the discourse is going to start to narrow and narrow and narrow even further. When you talk to privacy professionals, again, I did a textual analysis of op-eds and industry writings from privacy professionals at the IAPP website, as well as industry journals, and also conducted an ethnography based on semi-structured interviews with 52 privacy professionals at conferences that I attended in order to tease out some of the concepts. The number of articles that I used was 122 out of 678 I found on these particular two platforms. An interesting side project on this might be using a natural language processing algorithm to see what tech tools can tell us about the discourse, but we'll put that aside. Yeah.
I guess I'm a little confused between two things you said.
Sure.
So on the one hand, you said that people talk a lot about privacy, and that doesn't seem to have any effect. And including privacy professionals, they talk about it, but it didn't seem to reflect what actually happens.
Right.
But then you said the explanation is going to have to deal with discourse. And especially on the left-hand side here, it's not clear why that discourse should really matter all that much if, as you said, what people say doesn't really have that much effect on what they do.
And I think what we're going to get to when we get to the end of this slide is see that the real discourse that has actual power is the discourse of the engineers and the technologists. I think you're absolutely right. This discourse, although broad and makes sense to us, is exactly the discourse that doesn't have any power over what privacy looks like on the ground. And the implication, the conclusion, or the normative conclusion, is that that's unfortunate, right? So I think you're absolutely right, and that's exactly where I'm leading. And I think I violated the cardinal rule of a legal presentation as I hid the ball. When we make presentations, we normally say, or when we're arguing before an appellate court, always answer the question right up front, and then get to your discussion. But so we're leading in that direction. The point is to show that our discourses are the people that get closer and closer to the actual negotiation, the actual products that negotiate our privacy on an everyday life. The discourses are narrowing and narrowing. With respect to privacy professionals, their answers are far more driven by the flow of data. They talk about data flows and data collection and choice and the ability of individuals to determine for themselves if they're going to check a box or if they're going to allow a website to gather their information. But again, these discourses, as Paul mentioned, these discourses don't seem to have an impact on privacy on the ground. What really has the impact, however, seems to be the discourse of privacy among engineers, among the people who are doing the work of design at these companies. This research is based on some research that's out there as well. It also includes surveys that I've done of engineers inside several technology companies, as well as those embedded days in design meetings. Also, I'm happy to receive help on thinking about other ways to identify the practice and the work and the discourse of these populations. Technologists tend to have a different lived experience in terms of privacy than many of us. Their answers to questions about how they think about and how they do their privacy work is far more technology driven, which makes sense. Their mental frames about how the internet and how technology works are far more complex than us. So there are several discourses that become far more prevalent. Yes?
Where are the categories of privacy professionals and technologists drawn?
Yeah, so good question. So privacy professionals are more of the compliance-oriented people inside a company. They run the privacy system, or ostensibly they are intended as the people that technologists can go to ask privacy questions. These are the people that are actually coding and developing the products, developing the product code that either elicits information from users and so forth.
And as a follow-up, how much do people of one category think they're part of the other category?
Actually, there is, in terms of, although you can have a degree in engineering, computer science, and be a privacy professional, there's a lot of territoriality among these two groups. Privacy professionals do not see themselves, even if they have a computer science or engineering degree, do not see themselves as technologists. They see themselves as privacy professionals. And the territoriality of engineers inside companies is, of course, well known. And that I am not contributing. I'm building on that well-known research. I'm not contributing anything new there. Territoriality actually becomes an important part of this narrative because people in one group, the people who are making decisions about our privacy and code, very rarely actually will go to a lawyer or go to a privacy professional to ask questions because they feel that's not their job, right? And we'll get to that in a little bit. Yes?
I have a question about how you think about sampling. So when you have a topic as broad as privacy, sometimes people might be talking about it but not using the word privacy. Or sometimes people might be using the word privacy but not talking about exactly what you mean by privacy. So all of these seem like what you're going to learn depends a lot on how you do your sampling. So how do you think about that?
That's exactly right. And because and you can't just ask a question, well, tell me what privacy means to you. You can't even ask that of a non-expert out off the street. So there, the key role, the key research method is being embedded as kind of a fly on the wall in these design meetings and learning how different groups talk about these things. My experience as a lawyer and working in privacy helps me understand the language that people use when you're a privacy professional or when you're an academic here. But you can, by sitting in on these meetings and letting people talk in general terms, you get the language, and then you can refer that back. This was actually really helpful to read the work of Christina Nipper-Eng in this area, and Kang up here, on the work, Hugo Kang, on the work of mental frames of engineers when it comes to the internet, because they did that work for me. Essentially, they used interviews with people to first identify the language that these clusters use, and then use that language to identify answers to the privacy questions. So there are, as a result of this narrowing of discourse, my argument is that the discourse of privacy is going to develop more narrowly as more technology becomes, or as the design becomes more important in the implementation of privacy, and that's going to create a seismic shift from what we have today in privacy law to what we're going to have, I think, in just a few years, for the worse. Privacy today, so I'm going to get to the implications of this last slide in just a minute, by just setting the stage about how what kind of changes are going to be wrought by this technology discourse of privacy as code. Privacy discourse today, privacy law discourse today, is explicitly neoliberal in the sense that it's about notice and choice. Neoliberal in the sense that using market tools or market assumptions to kind of undermine social justice-oriented law from the mid-20th century. But the way we think about privacy today is about notice and choice. Companies have to, for the most part, provide us information about what they're going to do with our data, and then in long legalese, unreadable privacy policies, and then we have the option to opt out or use another service. That discourse, thinking about privacy in terms of choice, is actually prevalent in all of these. Everyone in every cluster, at least some plurality, if not a majority, at least some groups talked about privacy in terms of choice in all of this. So it's not so surprising that the law would integrate something that a lot of people, especially in an iffy, fuzzy subject like privacy, could agree on, about the right to determine for yourself when and what you're going to disclose. But this doctrine is explicitly permissive, explicitly deregulatory, or because this regime that we employ, that we regulate via the FTC in this country, for example, is all about self-regulation. You know, you put up a privacy policy, your data use practices are what you say they are. As long as you pretty much don't lie on that privacy policy, we're going to let you do a lot of things within certain minimal guardrails. And I have a very dim view about the FTC's ability to install those guardrails, but we can leave that discussion of the FTC's power for another time. The result of the discourse of choice being predominant in many of the different clusters has resulted in this discourse of privacy law that is itself absolutely terrible, right? Scholars for years have shown how poor notice and choice is in actually protecting our privacy, whether it's cognitive biases that make it impossible for us to understand what's in a privacy policy. Yeah.
What is protecting our privacy? What's the end goal of having our privacy protected?
Well, however you define it, it's our ability to effectuate our privacy preferences, right? So if we don't want our data collected for the purposes of behavioral targeting, protecting our privacy would be allowing us to effectuate or realize that preference.
But what about when you give consent to share your privacy in exchange for material or service goods, and then you only recant once your opportunity to have what you want is passed? Isn't that like taking a loan and then deciding you don't want to repay it when the terms come up?
No, it's actually like consenting to have intimate relations with someone a week ago and saying no a week later. So I think consent is something that operates at a particular point in time, and we teach this in sexual harassment training, and we teach this to young men all the time. Just because someone consented to have sex with you on Sunday doesn't mean that she consented to have sex with you on the next month, right? So just because you consented to the collection of data at one time doesn't mean that you consented to the collection of data in perpetuity. But I'll take your point and note that...
That's a terrible metaphor because there's retention of data. There's not retention of the state of population. So
There's not
retention of the state of population.
That's...
So there's retention of data, and so he's really saying, like, what if you go long, you don't want people to predict you yourself based on the data that was collected with consent?
I think that metaphor works to the extent that the point is that consent in time 1 does not mean consent in time 100. But I take your point.
But yeah, the pregnancy occurred at time 1. But at time 100, there's no way you can change the fact that the pregnancy occurred at time 1.
So I take your point. I think the additional point is that just because notice and choice functions like that, if that's the regime that we exist in, then one can make their choice at one time and make their choice at another time. And given our inability to, even at time 0, make adequate choices. So what I'm arguing is that first choice in the data collection context or in the notice and choice context is actually inadequate. We are unable to adequately balance potential future risks to our privacy against current rewards, whether it's convenience or a $5 Starbucks gift card. And we have people in the room who are doing great work on the role of dark patterns and manipulating our consent. But the point is here that even though notice and choice is an inadequate regime for protecting our privacy, it's at least scrutable. It's at least possible for us to determine whether a given notice is giving us adequate information in order to make decisions. We can interrogate whether people are making decisions that adequately reflect their privacy preferences. We can go under the hood to see if the notice is adequate. That's why so many laws talk about adequacy of notice or conspicuousness of notice, right? These are attempts to ensure that the notice is giving us adequate information to make our choices. The problem is that if privacy is implemented no longer through notice, but really implemented on the ground by the technologies that are designed, that we use every day, then really privacy is not being implemented through notice and choice, it's being implemented through code. And code is inscrutable. It doesn't matter if someone, except for many of the people in this room, it doesn't matter if someone gives the code of an automated decision-making system to someone who has been adversely affected by it, because that person nor her lawyer can't really understand it. And there are several cases like this popping up through the state court system right now. There were recipients of disability and Medicaid benefits in the state of Idaho and Arkansas, for example, whose benefits were cut by nearly half just because they switched from a system of a social worker coming to their home to identify how much benefit they get to a computer algorithm identifying their benefits. And when they sued for the reduction in their service, someone with ALS can't get by with only 20 hours of service, of in-home service per week. The court said the companies either refused to give over the code to understand how they came up with that result, or they just gave them source code and said, okay, here, figure it out. And it's difficult for individuals to adequately make their choices, and hard for lawyers to help individuals effectuate their rights when you can't understand what's going on under the hood. So, if real power of privacy rests with engineers who are coding in translation of law into technology, then rather than getting a bad but terrible regime to protect our privacy, we're going to get a regime that we can never assess whether it adequately reaches legal requirements.
What about, so there's a problem of literacy in other domains, and that's why there's expert witnesses. They're not perfect, but why are expert witnesses not the right solution for this problem?
That's a good question. So there are two problems with using expert witnesses in a litigation. As that litigation in Idaho suggested, there are expert witnesses on both sides. And so you're going to be kind of a fight to the experts, and you're going to reach a solution, or a jury may reach a solution between two reasonable sounding experts on both sides of a debate. The larger problem is that handling a problem like this with experts on a case-by-case basis does not provide any prescriptive protection for people generally. So I would rather use some more prescriptive form of law, whether it's statutory law or regulatory law or other tools that we can make sure that everyone, rather than having to go through an expensive litigation, can reap the benefits. But that's a really good question. And I think none of this suggests that expert witnesses won't play a role on a case-by-case basis. We just can't rely on that entirely. So I guess the next part of this argument is to identify, well, if I'm talking about a shift of the discourse, a shift of the discourse of privacy law from a discourse of choice to a discourse of code, well, what actually is the evidence that that's happening? Because the law still is notice and choice. But there's actually quite a lot of evidence out there that we are in a path toward making our privacy protections completely inscrutable, even worse than notice and choice. So first, in these meetings, in these embedded design meetings, interviewing engineers, it's pretty clear to me and clear to other people who have written about this that for many technologists inside these companies, again, I'm not talking about all technologists and all designers, this concept of privacy is wrapped up with the idea of encryption. Many engineers will say that, well, I did my privacy stuff because I made it encrypted from end to end. And, well, that's part of privacy. Encryption is a necessary and important part of protecting user privacy, no doubt. But it's a small part of the diagram, small part of the world of privacy. Privacy also includes limits on the flow of information and retention policies and and information about who has access to what and how much access, deletion, correction, things like that that are not necessarily included by encryption. And policies at these companies are being designed as if encryption is coextensive with privacy. If anyone saw Mark Zuckerberg's blog post on the new Facebook, which mentioned privacy a lot, but his definition of privacy was entirely based on encryption. Automation of decision-making, we talked a little bit about that. That's a perfect example of the implementation of law as code as opposed to law as choice. The automation of privacy compliance. One of the things that I've done as part of this research in an article that's going to be under submission soon is identify the now hundreds of companies that vendors that companies hire to do their privacy compliance for them. and essentially say, all right, I have these obligations that the GDPR, the General Data Protection Regulation from Europe, and the California Consumer Privacy Act require of me. I don't want to be bothered by this. Do it for me. And companies, these vendors, have created these technological tools that say, buy my product for $1,000 a month, and if you buy my product and give me the information that I need, you will be compliant with Article 33 of the GDPR. That is a legal conclusion made by engineers, and it's an example of technology, of code, being used to meet legal standards. Smart cities is another example. My research in this is what I'm doing right now, so I'm not super prepared to talk about details, but a smart city is a perfect example of translating law into code because it's a public-private partnership that hands over public governance responsibilities to a technology company that's embedding sensors in roads or in homes and so forth. And another thing that I noticed while doing this research is that the discourse of privacy as code actually preempts other competing discourses inside a company. So when I talk to privacy professionals, when I talk to even the CPOs who are privacy advocates inside their companies, and they will say, well, what we really need is X. And then I said, well, why don't you do that? And they said, but it can't be coded. We can't make our engineers get this, or our engineers won't be able to do this, integrate this into our product. So, and that was repeated. This discourse of preempting other privacy discourses was common at every level at every company that was part of this research. And although we can't see the result, there's no, here's this version of the iPhone that does X, and here's this version of the iPhone that did something else. But the cutting off of discourse is exactly one of the things that Foucault was worried about. That control of discourse means power. And if you preempt other discourses, you have control over what the product ends up in. Yes. All right.
A piece of a suggestion.
Please. Yes.
When you talked about privacy being equated with encryption,
Mm-hmm.
it wasn't clear from the way you were saying it if you're saying it's a type of discourse that happens to be common among technologists, including, for example, in the way we teach privacy in our computer science classes.
Right.
However, the way I would frame it is in a way that involves a substantial degree of disingenuousness and even malice on the part of the tech companies. And in particular, after the Snowden leaks, a lot of companies found it extremely convenient to play up those concerns and present network eavesdropping as the main privacy threat that consumers should be worrying about, and using that to distract attention away from the fact that the collection of data by those companies themselves was by far the bigger thing that people cared about. And by pushing for encryption, they were able to have this strong PR pitch of doing something about privacy while doing nothing at all about the thing that really mattered to people.
100%. I completely agree with this. And my point, and I think I glossed over it for the purposes of this talk, but in the book there is, I discussed that. I discussed the just disingenuousness nature of using the discourse of encryption, and then I say, well, even if that were not the case, if we want to assume, let's assume for the moment that's not the case, there is still a lacking of discourse still in CS programs about the larger privacy issues associated with beyond encryption. But I think you're right. I think that is far more of an accurate narrative to tell. When I talk about this, I often get pushback by saying, well, there also the engineers that we're hiring don't think about privacy coming in, and I say, well, that may be true also, and here's a separate related narrative. But I 100% agree with that. I just didn't. I kind of glossed over it for the purposes of this talk.
We do deserve some of the blame, I think, the way we teach it.
I think some, but I also think it's getting better. There are really good examples of some schools that are trying to change the education program, not across the board. And I did I had a research assistant help me do this interesting analysis. I found it interesting about going through course catalogs and then getting syllabi from teachers at various different top-ranked computer science and engineering schools to try to identify, even when their syllabi talk about privacy, like what actually are they teaching in those classes. And it turns out a lot of it is still system operation security, or system security, or encryption. But I think you're 100% right that that disingenuous discourse from the companies is super powerful.
I
Yes?
just want to ask a question about what you were just saying about, before all the questions go. Yes, definitely there's a power dynamic, and people can use this either for disinformation or I mean, because encryption does matter. It is one source of privacy.
Totally.
But yeah, obviously, like I was just saying, you can sort of support. But there are also facts of the matter about what you can and cannot do with privacy. There are technological things that the technologists have to be the ones that are ambassadors from the physical reality of what can be done and what can't be done. So are you, in your analysis, are you dividing between the two cases of where the power is derived from fact and where the power is just played around with for political purpose or to save money or something?
Well, I do talk about all of that. The larger project addresses not just the power of one group, but the power of marketing departments inside companies, the power of advertisers, the power of other stakeholders.
I'm not just talking about power.
I understand. But I mentioned that in the hopes of noting that there's a larger story here. But I'll also a little bit push back on this idea that while it is true that technologists are the translators, I think you used the word ambassadors, yeah? The translators or ambassadors. I actually love that. I think I'm going to use that phrase, and I'll cite you. Okay, excellent. I love it. Yeah, I love that term.
It's called dragons, knights, and evil bats. So it's more nice for but anyway.
Fantastic. And I do love the term. While I think that is totally true, I'll get to your question in a second. I think that is totally true. I think there is a preemption of other discourses when the limit of your imagination with respect to what a company has to do with respect to privacy is, oh, it can't be coded. Right? There are tons of other things that company structure, who reports to whom, that also reflect what a company does with respect to privacy that shouldn't be cut off by saying, well, it can't be encrypted.
I totally agree.
Can't be coded.
I was trying to see that point. I was just trying to make sure that you did also acknowledge that there were some physical facts.
Totally, absolutely. I think part of the strength is that, and this is related to Arvind's point, part of what I'm trying to argue is that I'm not trying to demonize engineers and technologists here. Let's even assuming the best of intentions and noting the facts that you say that sometimes there are these limitations, but there are these other discourses and other stakeholders and other factors that are making it problematic.
Thank you so much for your answer. I just want to push back a little bit on
Please, yes.
Technologists that you talked to, like your supervisors, and said, oh, if we wanted privacy, they would do that, but the coders can't do it. The coders are often the scapegoats, they can only do what they're asked for, and often it's about priorities that they have. So you can optimize the time that people spend in front of the screen, and you can focus on privacy.
Totally.
So if you look at problems with like the Equifax breach, I don't think that their software engineer was the one who didn't want to do updates. So I really like your point that it's not about demonizing any population, but figure out what the hitch is.
Yeah, it's talking about the structure, right? And I address this point directly in my Designing Without Privacy article in the Houston Law Review, where I talk about that there are a lot of demands on the coders and the engineers at the bottom of these design teams. And a lot of those demands are sometimes conflicting, but also I get these comments from engineers. I'll just give you an example. I have 42,000 things to do, and privacy may be one of them, but I can't be in front of the computer, as you say, 30 hours in a day, right? So sometimes privacy gets short shrift. My point in including that narrative in the original research was saying that this disconnect between what people want about privacy and how it turns out on the ground is not always nefarious, right? It just happens that there are a lot of things happening. I think there are some trouble afoot with some of these stakeholders and the power dynamics inside companies. But you're 100% right to note that structural problems outside companies are contributing to this. And I address a lot of those in Designing Without Privacy, and we'll return to in the larger book project. So thank you for your question.
I think it sort of is related to this, but slightly different in terms of them being sort of the fall guys or girls in this scenario.
Mostly guys, unfortunately.
Yeah. Is there a way in which the business model is just the answer?
Yeah.
Because they're based on data, They're not going to do anything that's going to really screw that up, and in which case it's a material rather than a discursive explanation. It's just the economic model, and maybe one way to sort of examine that would see, do engineers that are less focused on data, ostensibly Apple versus Google or Facebook, do they have different kinds of privacy approaches or violations or something?
Yeah, so this is a really good point, and what I will distinguish between, I'll first mention that what I'm arguing in this presentation and in this chapter/paper is the discursive part. The book, as you notes that it's not just a discursive problem. So I'll say that first. Second, what I'm really talking about is the implementation of privacy law. So I'm not talking about all of the everything that engineers think about. So when we're dealing with, say, the GDPR, we're talking about data being ambassadors for data policy into code. I did have the opportunity to talk to engineers and technologists at a variety of different companies, not just the Googles and the Apples, although some of my previously published research focused exclusively on those interviews and those policies, but also talk to people who are doing websites for a retail company, or people who are doing data collection design for companies whose website is not their primary, whose data collection is not their primary business. These kind of discourses crop up among so many of these clusters, but I take your point that it's not just this narrow problem. Is that a hand?
Yes.
Yeah.
So in the spirit of suggesting more possible social
Please.
variables that
Yeah.
might be playing a role, I'm really curious about the extent to which consolidating power in the design and the construction of technology is having the impact of sort of creating institutional rigidity with respect to privacy implementation, because rather than allowing sort of what's on the books to be interpreted in a variety of different ways, they're sort of fixing it in the most rigid interpretation possible in a way that, as you said, is not necessarily understandable to consumers, and it's not really possible to sort of work around it.
Yeah, I think that's a really subtle and cogent point, and I think it's broader than what I was trying to say with respect to cutting off other discourses, but I think it's related, right? I think your point is that the power concentration into one group kind of metastasizes the power of this discourse of one group or the work of that one group. And I think that's right. I think that's a really good way. I should probably, and I think what I should do is include in when I talk about cutting off other discourses this exact point. And I think that's really correct, and I hadn't yet thought about it broader because I was focusing so much on the data that I was receiving in these interviews. But that's a really good point. And I think that's also a good segue into thinking about what are the forces that are really translating into transforming our discourse of privacy law from what it is into privacy law as code. I mean, you talked about these structural issues. I think there are some other social forces that are at play in translating notice and choice into privacy as code. And these are some of the things that I had thought about based on my research, but I'm very much interested in what other people think about. Here, what I mean by proximity. These are 4 social forces that I think are contributing to the transition of privacy law as code and discourse. Proximity. This is actor network theory. This is the idea that the people who are closest to doing the work are the ones who are going to dominate and have power over that work. So when engineers are the ones in design meetings, when engineers are the ones who are making decisions about privacy ad hoc, in my research I found that as privacy issues or as data flow issues come up, if they notice them, don't always notice them, if they notice them, the first place to go is to their manager, who's also a coder, a promoted coder. And the next place to go is to that manager, who's also a coder. And then the next place to go is to the project manager, who is not always a technologist, but often is, especially in the bigger companies. Project manager becomes incredibly important in this, in diverting the course of where these questions go. But only later and later does it ever get to a privacy professional or a lawyer who may be qualified to spot the issue, if it gets to them at all. Complexity is this idea that what all professions do. Lawyers are really terrible offenders at this. We make real estate contracts look so look so complex with so much jargon that no one can understand them. We do that with privacy policies too. Well, technologists do that as well by hiding behind the complexity of code by saying, no, you can't have access to this because if you had access to it, you're going to take away our trade secrets, and also, okay, fine, we're going to give you access to it, but people can't understand it. So they hide behind complexity in order to retain their power. That complexity is laundered through, or the nefarious activities that Arvin was talking about a little earlier, is laundered through the agnosticism that engineers come to thinking about technology. Not all, of course, but there's a mantra in a lot of these companies that we're just coding, we're just making phones, we're just making a search platform that's agnostic about the discrimination or about the power asymmetries, that's agnostic about the biases of the data that's pumping into our automated decision-making systems. Of course, as many people in this room know, those technologies are not agnostic, but the discourse is that technology is agnostic about those things. And then, of course, status. It used to be people went to law school because they knew that was a great entry point to a six-figure salary and a stable life. Nowadays, we valorize Silicon Valley. We valorize the tech genius who dropped out of college in sophomore year and created a multi-billion-dollar tool to help him get girls. Like, we valorize these people, and as a result of valorizing that cluster, their status as well as their discourse becomes the discourse that law and policymakers and people and ordinary non-experts tend to adopt as well. All of these factors are working together to make code the most powerful tool in implementation of privacy law. And then the last thing, of course, is what do we do about it? What kind of solutions, legal or extra-legal solutions, are necessary to address this? In some of my previous work, I talk about how we need endogenous as well as exogenous changes to how we educate engineers, to the guardrails that we put around companies to prevent them from being so disingenuous about what they're doing when they collect data. And there are legal changes, there are doctrinal changes. We can go into that more detail in terms of questions. But I also think we need to be far more robust around the guardrails we put around things like automated decision-making and technological tools that have direct influence on how we live our lives. Nowadays, it's a matter whether it's notice and choice, or more likely, there's some procedural guardrails. The GDPR includes privacy impact assessments. These are documents or systems that you have to follow to track how you develop technology in order to show some potential regulator that you went through these processes and you thought about privacy. These process-oriented, and we have algorithmic assessments, things like that, all of which are taken from environmental law. These processes are band-aids that can also be manipulated. As one of my articles show, using the work of Lauren Edelman, I show that companies are turning these procedural frameworks into just checkbox privacy compliance, and then using engineers as scapegoats from when they fail to comply with actual law. So what I think we need is we actually need far more robust enforcement. We need to enforce things like privacy by design, which require companies to make privacy choices inside the companies, and also stop being such paranoid regulators. When the FTC decided to settle with Facebook, they immunized Facebook from all previous wrongdoing associated with anything they've done prior to the settlement. And the argument, the discourse around that is, well, regulation stifles innovation, and we have to stop doing that. We have to learn to interrogate the codes that are coming out into our products, almost like we did with products liability for design defects. Our cars are safer now because law forced regulators and engineers who were designing products to interrogate and to actually change the code of what they were developing. And we need to apply the same type of rules to software. And there's no reason why I think we shouldn't. It's not just a matter of changing the code, it's a matter of changing the structure of how these companies operate. And I'm open to your questions. Thank you already for the questions in the back. And I I really appreciate the feedback of additional areas to research, additional questions. Yes?
So my question, I think, relates to what needs to be done, but actually is methodological in nature. So the distinctions that you draw between this choice-based model and the code-based model, I can think of like real-life examples that would fit this description, like the website which says like take it as it is or leave and go browse Google, and on that hand some systems where that their session is timed and then it's erased every 10 minutes, something like that.
Okay.
Like most of the services and tools that we use are sort of the combination, right? You have some choices and they're translated somehow in code, but I think the question is, I understand your criticism of choice as a system of decision making, right? But also what kind of choices are you making? How, are they understandable? Are they detailed enough? And so forth. And also in code, is it effectively implemented, or even if the code says that this information should not be retained, there is some backup system that actually does retain it. So
sure.
In terms of making improvements in practice, I guess the real empirical data that you will collect will require you to sort of look at this in combination rather than as two distinct.
True, no doubt. True. There's no doubt that there are times right now where we have both choice, although I argue that it's completely ineffective, and also code-based implementations of what privacy law requires. I mean, that's part of the point. And you're right that any analysis of the data that I'm collecting, whether it's observations or whatever, has to integrate the how sometimes these two tools work together. I think my point is that we're going far into one direction in terms of complying with privacy laws as opposed to a non-technological means. But I take your point that there's more, I guess that's second order or below the surface answers to be had in terms of what to do. I scratched the surface just for the purposes of the talk. But thank you, and we'll follow up later. Yes?
So you talked about this a little bit, but I wonder if there's a lot more there to distinguish between companies that destroy our privacy inadvertently because they're cutting corners and it's convenient, like the title search company where you get your title report as a URL and you realize if you change the number by one, you get the next person.
Right.
Right? And they're not making more money off of destroying my privacy. Their engineer cut a corner.
Yeah.
Whereas there's other companies whose main business model is to sell our data.
Mm-hmm.
And it's not a matter of cutting corners. It's a matter of that's where their bread and butter is.
Right.
And so you mentioned this a little bit. You said, there's this retail site that does this. But that's really...
I think that's an important point because what I'm interested in is both. I'm interested in situations where, not just the situations like Uber, where they were, some people would argue that Uber is changing, but they were so not just careless, but they actually abused our privacy in order to pad its bottom line. But I'm also interested in those companies where privacy just doesn't come up. It's not even thought about, because that's problematic as well, right? So those are the two dynamics that you're talking about, and at least with respect to this narrow part of the larger project, the discourses when it comes to privacy are similar when it comes to the different clusters, except of course the people at the top. The difference is that there's no disconnect, that the invasion of our privacy is the whole goal, right? So I took as a baseline the idea that there are people out there who are running companies who do care about our privacy. And even there, our privacy doesn't get implemented on the ground, because I thought that was a more interesting story to tell. But the project, of course, includes the great examples of the people of the companies that are abusive. In the spirit of getting new questions, we have people here who haven't asked before.
Yeah, I just had a question about regulatory policy. I think we see, Europe and California doing different things than the United States, and I think you're talking about finding ways to create regulation that systematically changes companies. I think right now companies are often setting up parallel structure so they can still maximize profit in places where regulation isn't being
Mhm,
increased.
mhm.
So how do, different regulations taking place in different places play into sort of your thoughts about the change we need?
Yeah, fantastic. So there are lots of people who think the GDPR is the best thing since sliced bread, right? And that it is going to change dynamics and the world is going to be totally different. We already have evidence that that's not the case. The investigations from European data protection authorities look exactly like they did under the Privacy Directive. The CCPA, in some ways, is broader in their definition of public-private information, but in a lot of ways it's also narrower. It's an opt-out regime. I don't think these are laws that are changing structure. I think they're important parts. The right of access, the right to deletion, those kind of things, those are important parts of retaining control or protecting our privacy. My hope for real structural change involves a combination of new laws, perhaps, although there's great disagreement in CITP about this, perhaps by treating companies like fiduciaries of our data. I know there's robust discussion about this. And what I mean by fiduciary is like lawyers and doctors have to treat our information with some modifications, as well as more robust enforcement. I think the FTC is structurally inadequate, structurally unable to regulate our privacy, not just because they're understaffed, but because it's a market-oriented agency. It's there to protect markets. The market for privacy.
Even in its name.
I'm sorry?
That's even in its name.
Yeah, exactly, right? So, and yet it just became our de facto privacy regulator because it just happened, which is an interesting sociological story as well. We need a new agency that's going to be use far more robust approaches. One of the things I talk about in this project is the FTC requires these companies to complete assessments every 2 years after they're under a consent decree. An assessment is not an audit. It sounds like an audit, but it isn't. An audit is done by an independent third party doing internal investigations, going under the hood and seeing what's going on, seeing how the sausage is made. An assessment goes something like this. Question A. Has the company complied with Section 3 of the FTC consent order? And the answer is, according to, based on evidence in Appendix A, yes. And then Appendix A is all proffers from the company saying, yes, we've complied with Section 3 of the FTC consent decree. And I'm not joking. Like, I've reviewed redacted versions of these assessments, and that's quite literally what they say. So if we're going to have a regime based on that, then there's no law that's going to help us, so we need a combination of exogenous and endogenous change. Yes? We have a few minutes.
My question is, a lot of your talk today has focused on technology companies and what they can potentially do.
Right.
And that is critically important because that hopefully allows us to have a centralized action plan versus the other side of the debate. How can we get people to care more about their privacy? Because so much of our data is already there. A lot of us feel very hopeless that we are going to be at a place where we could even take it back and that the Pandora's box has been opened.
Yeah.
How do we counter it? How do we regulate it? How do we think about the future where privacy is even a possibility?
Yeah, this is a super common question, and I wish Arvind was still here, but I think there are other people here who are working on the dark patterns work. But so there's this presumption that people don't care about their privacy. Even my students say that, oh, the younger generation doesn't care about their privacy, which makes me feel really old. But it's also not true, right? People say that people don't care about their privacy because there's a disconnect between responses on surveys saying they care and then what they actually do in real life. But in fact, we don't realize our true privacy preferences because of our own cognitive barriers and because of design manipulations from the part of companies. So if those were actually regulated, if dark patterns were actually regulated, and Mihir and I are talking about what kind of legal standard do we develop in order to know when a dark pattern rises to the level of unfair and deceptive business practice or whatever, if we clamped down on that, we would see, I think, far more effectuation of our privacy rights in these technologies. But that's why we need, but in addition to get people thinking about it, we need far more robust scholarly and advocacy work to create a movement around this. I think Snowden was a moment. I think Cambridge Analytica was a moment. And any great story, any great sociological story about social movements will tell you that there are these important inflection points that are important over time. And I think we're in the middle of that. We're not there yet. And who knows, maybe my book will be an important inflection point. But the 4 people will read it will have to have outsized influence. Any other questions? Yes?
Yeah, so I was wondering how you think engineers should treat this power of the discourse and privacy that you're discussing. So, like, for example, should engineers go against the orders of those above them if they think that there's some aspect of the technology that they could implement that has, like, some public benefit?
Yeah, really good question. So let's take first the far more common situation where no one thought about it, where there isn't an order, like from a nefarious company like Uber that says, screw these people's privacy, just do X. Far more common is that it's not a priority in design. Engineers don't know how to spot it. There's no one there in the design system that can spot it. So I think a lot of the work would be done by at least noticing the privacy issues better. And that comes with training. That comes with a greater corporate commitment to privacy. And it comes also with putting sociologists and lawyers and other people inside design meetings, which I know engineers in the room might find offensive, but I think it's kind of what we need. But to your point specifically, is there a point for civil disobedience or creative resistance when a company wants an engineer to design something that explicitly invades someone's privacy or explicitly violates the law? And the answer is absolutely yes. We see civic engagement from employees across these technology companies, whether it's for against gender discrimination, inadequate hiring, and so forth of diverse populations, issues related to guns, and so forth. It's high time that we channel that civil interest into protecting privacy as well. So I actually came across an engineer who had this exact situation, who said, well, I got these specifications that said I had to do X, Y, and Z in this code that I was working on. A, I didn't know what the rest of the project is doing. I'm only working on this little part. And B, but even still, so I don't know what they're doing to protect against privacy, but the stuff that they told me to do, I know because my sister is a lawyer and we talk about this stuff, and that's pretty bad and that's pretty creepy. And even without that, I would seem that it's pretty creepy. So I asked him, well, what do you do about something like that? It's like, well, I knew that my boss wouldn't help, so I went all the way up to the project manager's boss. So project managers have their own, at different companies they're different things, but whether they're vice presidents or whether they're like directors, there is someone who's in charge of multiple products, and that person has direct line to a lawyer or a privacy professional. And then they came down hard on them because finally someone who cared about it said, you can't tell this engineer to do this stuff. You should have asked us first. And that shows you, because part of this project is also about how privacy departments inside these companies are kind of separate structures that you just have to kind of run it by, and they check the box, and they have this paranoid approach. It's like, well, we don't want to get involved, we don't want to interfere with innovation, so they don't really get involved. And as lawyers know, when you tell your boss no too often, they're going to stop listening to you. But the problem is, it's just not getting up there. So there is a way, even inside the system, for engineers to show pro-privacy civil disobedience. And I hope you'll do that.
Have you run across issues with like reprisal? So engineers trying to take a stand or suggesting that they're worried about, not following orders?
Yeah, issues of reprisal with respect to privacy I have not come across. I've interviewed a lot of current and former engineers, so people who have left the companies that they did this work, and I've never heard of anyone being fired because they tried to implement something with respect to privacy that the company didn't want them to. Partly because there are lots of people, for all the great things that engineers now understand and that people who were in this room a few minutes ago understood, is that they're doing their work. They understand. Some people understand this stuff, but a lot of people in the trenches, like you mentioned before, they have 42,000 things to do and they just can't. Right? So sometimes it's not necessarily a nefarious cavalier approach to privacy. It's just, I didn't notice, I was too busy. But we also have to address those problems because I think that's the largest source of some of these errors. I'm going to stop this. Thank you very much. I'm going to